So I'm going to call this meeting of the West Hollywood Rent Stabilization Commission to order. Please join me for the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Secretary Brino, may we have a roll call?
Commissioner O'Keefe.
Present.
Commissioner Kerpes.
Here.
Commissioner Maggio.
Present.
Commissioner Martz. Here. Commissioner Topchian.
Here.
Vice Chair Bergstein.
Here.
Chair Charity.
Here. Thank you. Unfortunately, to begin this meeting, I have an announcement of an adjournment motion. Commissioner Buckles, our former Commissioner Buckles, her brother has passed away. So I'd like to adjourn this meeting in the memory of former Commissioner Buckles, David Buckles. Thank you. Passing. Are there any other adjournment motions? No. Thank you very much. So then we'll move on to item 4, approval of tonight's agenda. Commissioners, having reviewed tonight's agenda, do I have a motion to approve or a motion to amend?
Motion to approve.
Second.
Thank you very much. All those in favor say aye.
Aye.
Thank you. Moving on from item 4 to item 5, approval of the minutes of our last meeting, February 28th, 2019. Commissioners, having reviewed those minutes, do I have a motion to amend or approve?
I had one amendment on page 4. It says that I attended the Cannabis Forum, and that was the Candidates Forum. There might be some overlap there, but it was the Candidates Forum that week.
I'll make that amendment before I sign it.
And I have one possible one. I think we discussed last meeting agendizing for a future meeting, having a rotating chair, or discussing possibly doing that. And I'm not sure I saw that reflected in the minutes.
Yeah, we didn't have that reflected in the minutes. I want to talk to staff. Do we have to formally agendize that, or can we discuss it in commission comments this meeting?
Yeah, we'll have to agendize that, and I apologize if you wanted that on your meeting tonight. You won't be able to talk about it, but we'll get it on the agenda at the next meeting.
Okay, and do we need to amend the minutes to reflect that it will be agendized in the future?
We can add a line if the commission's comfortable with us just essentially adding that line in. We can go ahead and do that. You can approve it with that amendment tonight.
Perfect, thanks.
Very good. So we have the minutes with those 2 amendments added to them. Do I have a motion to approve as amended?
I'll make a motion to approve as amended.
Thank you very much. I'll make a second. All those in favor, please say aye.
Aye.
Thank you very much. The minutes of our last meeting are approved. Moving on from item 5 to item 6, public comment. We do have one public comment this evening. If I can find it in my papers. I know your name is Ted, if you would like to come forward. Yes, Ted Green.
Thank you.
I believe you have 3 minutes to speak, Ted. Please state your name and city of residence and make sure you speak directly into the microphone so we can hear you.
Thank you very much. As you said, my name is Ted Green. I'm a longtime resident of West Hollywood. I'm disappointed that once again your agenda does not include a review of the staff's proposed 1-year minimum lease on dwelling units in the city of West Hollywood. What the city staff is proposing is requiring that all single-family homes, condominiums, and apartments built after 2001 be leased with no less than a 1-year minimum lease. Although I know at least one council member has told me that she believes this should apply to all apartments in West Hollywood, regardless of when they are built. That is a significant, impactful housing policy, and one of the missions of your commission is to review and make recommendations to the City Council regarding housing policy. Coincidentally, after your last commission meeting, the next morning, John Kehoe, the planning director, had one of his regular Java with John open meetings that I like to attend. And I brought up this issue at that meeting, and I let him know that it had been an issue of discussion the night before at the Planning Commission. He told me 2 things that I want to pass on. One, this zone text amendment is going to come back to the city, or come to the City Council no sooner than May, which means there absolutely is time for your commission to weigh in and have your views heard. Number two, when I mentioned to him that it had been a topic of discussion, his response was, since the zone text amendment is written not to cover rent-controlled apartments, it's really of no concern to your commission. And I explained to him, one, a plain reading of your mission is to review housing policy, and this is housing policy. And number two, even if the zone text amendment stays as currently written and requires a one-year minimum lease on apartments built after 2001, that policy is still going to affect apartments built before, because if you preclude less than one year leases on newer apartments, it's going to push that market onto rent-controlled apartments. So nothing exists in a vacuum. Long way of saying, I sure hope you'll take it up. And it raises the question, who's in charge here? Is it our elected officials and their appointees, or the city staff? I would argue it's supposed to be the elected officials and our commissioners who are giving direction to the city staff. Thank you.
Thank you. We have no further public comment. So we'll be moving on from item 6 to item 7, our director manager's report, and we'll have that from our housing manager, Mr. Peter Noonan.
Thank you. I do want to review our calendar, and then I have one update for the commission. So we do have one appeal on the March 28th meeting date. That evening, I will not be present. There will be someone here in my place. And then looking forward on each of the meetings from April 11th through May 25th, you do have 2 appeals. So we have not scheduled anything else on those nights because of the double appeals. Now, back in on November 8th, we brought an item that was an amendment to the Rent Stabilization Ordinance. This was an amendment to Chapter 17.48, which would, the amendment was to extend the beneficial evidentiary presumptions on costs for seismic retrofitting to soft-story buildings and to pre-Northridge steel and concrete non-ductile frames. We are proceeding forward with that amendment to the council. I know that the commission had asked us to return. There had been some questions that evening and some interest and consideration for looking into the net operating income mechanisms that are part of that chapter. But ultimately, that item was direction from the council to use the existing mechanism that we have in place and to extend that mechanism to the other types of seismic retrofitting. And so we did bring that to the commission because the commission had spent a year looking at a pass-through and looking at the NOI formula, and this was closure on that process. It was also an opportunity to share this with the commission. The commission has been very interested. Commissioners are interested in amendments to the Rent Stabilization Ordinance. However, ultimately, this was direction from the council for staff to follow the existing process. So we will go forward with that item, although I want to recognize that there was interest on the commission to looking at that formula. And so that the commission knows that there is another means that you can use if you want to ask the council for direction to review sections in the ordinance, and that would be to one of you or a number of you can raise that item. If the commission agrees, you can put a discussion on your agenda. You can make a recommendation to the council that you consider and look at those formulas if you would like. And with council direction, they would direct the commission to explore that in the future. So I'm not saying that it's a cut off dead end, but because I know that there was some interest, but that I also wanted to be fair and tell you that we are moving forward with the item based on the council direction, but that there is another avenue for you if you would like to continue the discussion and the considerations. This concludes my report.
Commissioners, any comments or questions for staff? Yes.
I have a question. So About 2 years ago, in 2 years ago, April, the city council passed the ordinance requiring the seismic retrofitting. It took effect a year later. We know that there was a preliminary list that was created of those likely properties to be affected, and I'm not sure exactly where that stands now. I know we were potentially going to wait to have the formal notification to all the landlords until this decision was made about how to adjust it. Is that the only holdup? Once this is done, will those letters be sent out, or does something else need to happen first?
Yeah, that's a great question, and those letters will be sent out. The Building and Safety Office is preparing that now. Also on this April 1st meeting agenda, there is an item, a seismic update for the council, and there's additional information on that. And also on grants that the city's going out for to help landlords with some of the costs. And so look for that all to happen in the very near future. I don't want to give you an exact date, but I believe that it's within the next 30 to 60 days that the notices will be going out.
Okay, I appreciate it. I would have been interested in us re-looking at the NOI, but I know there's a lot on your plate, and I'm happy to hear that we're moving forward quickly so that these buildings can be retrofitted.
I have a couple of questions. There's nothing in this, in the NOI that prevents excuse me, a apartment owner from retrofitting their apartment building now, correct?
Yeah, that's exactly correct.
I appreciate the update on the NOI and that the intention is to move forward. What is different now than what it was on our meeting after in November when we met in December? What's different now from then? Why it wasn't brought back to our commission?
You know, really, in all honesty, it's just been timing. There was no intention of not coming back with some form of an update to the commission, but it wasn't, there was no urgency. There really honestly isn't any urgency now of taking the item forward except for their synergy with the notices that are going to be released soon, and with building and safety coming forward with 2 reports. And so, I will tell you in all honesty, I originally had asked to push the item a little bit farther because of other priorities, but then seeing the synergy in between the reports that the Building and Safety Office is coming forward with, I think that it's meaningful to just take this all forward as one package to the council. I think that it's wonderful to be able to share that we have the grant opportunity and that we're going forward with that, and so we have some ability to support or augment the costs for seismic in a meaningful way that I think could prevent or be a different avenue from an NOI formula.
I would ask if it's all right, if the director could be sure in his report to the council, whether it be written or verbal, that it be known that at least one of the commissioners did not have a full ability to comment on the item because of the belief that it was coming back. Thank you.
We'll add that in, and so the commission knows as well. We did intend to recognize that we did bring it to the commission, and that the commission had comments and some concerns, and we were going to summarize those based off of the minutes. But again, I also want to remind you that you do have the avenue of communicating with your council offices, and you could also take that action of creating a recommendation to the council to ask the council to bring the item to you to study.
Just a quick, I probably need some clarification regarding what the public comments said about the 1-year lease versus, for rent control units, regardless the length of the lease agreement, whether it's 6 months or 1 year, after expiration of the lease, the terms will continue automatically, will go month to month. That's correct, right? So we have that in West Hollywood.
That is correct. Yeah.
So I guess my clarification would be is just what's the really importance to, have an amendment to require to have a 1-year lease even if it's a 6-month lease, the terms will automatically go month to month after expiration over that 6 months or even 3 months lease. So I would just say that that's maybe the reason we don't really see an importance to bring this up. Just to clarify, thank you.
Commissioners, any further comment or question for staff? Very good. So now we'll move on from item 7 to item 8, commission comments. Commissioner Maggio?
I just want to mention that I did attend the Human Service Commission, and the chair will give a report later on the community study summary, which was very fascinating. But as I go to these various commissions now, I do not say I am the liaison. I use the article a liaison, because I think we're going to want to reestablish what commissioner goes to what commission as a liaison, or do we want, we might want to have a discussion in the future, and maybe we should do it soon, as to who is liaison. I know Rob likes to go to planning, and I know Josh has, I forget where you went, Josh. I don't know where you're going.
The office.
But we might want to reestablish that. And if we want to share the responsibility, or if we want one individual, which often puts the face on the commission. But I did attend, I found it very interesting, and the report, which will be coming up, was really also very informative. Thank you.
Commissioner O'Keefe?
I like Commissioner Maggio's idea, and perhaps we could discuss that on the 28th, since we have just one appeal on that day, if that's of interest to other commissioners. I don't know if we need to formally agendize it.
We would need to agendize. Anything we want to discuss, we have to agendize, so
Okay.
I think we know that already.
Well, I guess I will make a motion, or would you like to make it?
You make the motion?
That
I'll second it.
that we discuss on March 28th, ideally. Are you saying we don't need to do this?
No, we'll go ahead and agendize that. It's been a
Okay.
little while since you've appointed your liaisons to the different boards and commissions, so we'll go ahead and put that on your next agenda.
Okay, great.
Thank you.
And I also wanted to thank Mr. Green for coming and speaking at the last 2 commission hearings. We definitely heard you and appreciate your input. I don't know if you were here for the entirety of last commission meeting, but we are planning on having that item come to our commission prior to it going to council.
Commissioners, any other further comment? I just, want to highlight during our meeting that March 28th is only one appeal, and you'll see that we have 2 appeals for all the meetings thereafter. So if you have anything coming up in the next round of commission comments, this would be a good time to add things to the agenda, because it might be take it or leave it. We're going to be busy for a while. So.
Good idea.
I have a couple comments. I can't even put into words how disappointed I am to hear the manager's report this evening. And again, I do appreciate the fact that he's giving us a heads up. But to me, it's pointless to bring something to this commission for us to rubber stamp it. I think in that November meeting when we discussed that issue, maybe not at the, I think a majority of the commission did probably have an opportunity and understood what we were discussing. I, for one, did not. And when I expressed that, it seemed to me that a majority of the commission agreed that this should be brought back. And when that was agreed upon, I basically stopped trying to figure out the whole issue right there at the dais, and knew that I could take a little bit of a breather and would look forward to staff then presenting us additional documents and answering the questions that were asked that night. So it's extremely disappointing to hear that basically that meeting was a waste, and the council will get no or very little solid information from us when that was what they had requested, and we've had plenty of time to go over that issue. Second thing is, I'm not sure if I left the commission meeting last month, or the last meeting, with the understanding that it would definitely come back to us, the one-year text amendment, but I was happy to hear from the manager after the meeting that he was going to try, and that he was going to work to see that we could have a venue for us to comment on that, because I think it is important. I mean, I think without discussing the issue specifically, one comment that was made here this evening from one of the commissioners shows that there is more to discuss than just simply saying that 1 year would apply to everybody across the board and they would be safe, because there's more details to it that makes that not true. And I'm not saying that we will change the policy in the end, but at least our job is to advise the council. It's not to serve as a resident of the city of West Hollywood and go and talk to your council member. When I say your council member, I'm talking about the reference to a council member appoints one person to serve on this commission. I, for one, am at large. And even when I was a direct appointee, my council member never sent me here to carry out his or her mission. It was always to serve in the best of my ability and to provide my feedback as a whole so the group could then give the comments to the council. So I don't need to be reminded every meeting that I, as a citizen of West Hollywood, can go and talk to my council member. Everyone can. Our role is a little bit different, and I would hope that not only would we realize that, but we would hold staff accountable in making sure that we are able to carry out our duties, because that's not what we're being allowed to do at this point. And that is all of my comments. Thank you.
Thank you, Commissioner Kerpes. Commissioner O'Keefe.
I have one more. In light of that discussion about the 1 year lease question, given that we have 2 appeals, every hearing from April 11th to May 25th, and this issue could go to council again, maybe whether or not we have a presentation for planning, we should just agendize discussing our own opinion on that topic on March 28th. So I would make a motion that we add to our March 28th agenda a discussion of the policy as it was whatever it is at this point.
I would second that. That's a really good idea.
So we do have a motion on the table. Secretary, may we have a roll call?
Commissioner O'Keefe,
Aye.
Commissioner Kerpes,
Aye.
Commissioner Maggio,
Aye.
Commissioner Martz,
Aye.
Commissioner Topchian,
Aye.
Vice Chair Bergstein,
Aye.
Chair Charity.
Aye. Thank you very much. So that will be on the March 28th agenda, and we'll take care of it. Commissioners, any further comment before we move on?
I'll just flag that I'll have more comments in the second round, so you're prepared. We don't get to leave right after.
I will too. But we want to be courteous to our audience, so we'll move on to the appeals if we're ready. I believe so, yes. So first, we're moving on from item 8 to item 9, our appeals. We'll be starting with item 9A. This is Appeal D-4347 at 1009 North Sweetser Avenue, number 14. Both parties have appealed this, so I'm going to ask, is Spencer Madoff, the landlord, present? Or a representative? Yes, thank you. And then Nicole DeSanto, the tenant, present. Thank you very much. We're going to have a staff report before you speak, so thank you very much. I'm just making sure you're here. And at this time, we'll have a report from staff on this appeal.
Good evening, Chair, Vice Chair, Commissioners. Jonathan Hollab, Staff Attorney. In this case, the tenant filed an application for a rent decrease and a determination of the maximum allowable rent, or the MAR, and whether any amounts over the MAR had been retained by the landlord. Nicole DeSanto has lived in Unit 14 since 1994, and as of August 2018 was paying rent of $553.11 per month. The tenant was awarded a rent decrease on a number of issues and denied on a number of issues. Both the landlord and the tenant have appealed the hearing examiner's decision. The tenant appeals the following issues: paint valuation, kitchen cabinets, bathroom flooring, unpermitted washing machine, and the MAR determination. And the landlord also appealed the decision regarding the MAR. Staff recommends that the Commission affirm in part and reverse in part the hearing examiner's decision. There is substantial evidence in the record supporting the hearing examiner's determination on the issues of the paint, bathroom flooring, washing machine, and the MAR. On the issue of the kitchen cabinet, staff recommends that the Commission reverse the hearing examiner's decision in order a $3 rent decrease per the valuation guidelines. There's substantial evidence in the record supporting a finding of a failure to maintain this housing service in compliance with the Health and Safety Code. I'm available for any questions.
Commissioners?
Go ahead, sorry.
Sorry. Okay, thank you. I have, at this point, I have only one question about the MAR. regarding the little evidence produced by the tenant. Since 1994, the tenancy started in 1994, so, and I agree with the examiner that in order to determine the MAR, the general adjustments beginning September 1996 should be used to calculate it, to see. Now, my question would be, whatever decision we take, whatever decision we make tonight, can this issue come back again? Can the tenant bring this matter back to the examiner at one point, and when?
A new application can be filed within 6 months of the final decision of the commission. That's the standard rule. That can be waived
Yeah,
by
I
the
was going to ask the
commission
second question.
if you so choose.
Okay.
But the normal procedure is a 6-month gap between the final decision and the new application. But of course, if the tenant then compiles information that would help support a decision, she can refile.
All right, thank you.
Jonathan, I believe the city stopped keeping records on maximal allowable rent sometime in the 90s. So could the city be at fault in any way here in establishing a MAR?
No, since the enactment of Costa-Hawkins, the city has required the filing of a re-registration upon vacancy, which I'm sure all the commissioners are familiar with. So the only thing, so long as the landlord complies, that the city will have is the initial rent, which is the initial MAR for the unit. Beyond that, there's no way of knowing what annual general adjustments have been implemented unless the landlord and or the tenant keeps those records.
Burden would be on here. The burden would be on the both the tenant and the landlord, right?
They're the only ones that would have those records.
Thank you.
Does the city, I imagine, has the records of what the AGA was every year going back to 94, right? So what I wonder is we can't establish for certain whether or not any AGA was taken, but it seems like at some point we could know that something is in excess of even if they had implemented every AGA. For example, if they were charging $2,000 a month and it started out at 300 something, we would know for sure that exceeded the AGA. And I'm wondering, I guess you weren't the hearing examiner, but I always wonder why they don't just do the math to find out whether or not what's being charged exceeds what every AGA implemented would be.
I think in prior cases that may have happened, but I don't think that that was an issue in this case because I'm not sure. I'd have to look at the numbers, but whatever the rent being charged now wouldn't be above that amount necessarily, but what you're stating is possible. I don't think that was an issue in this case.
In this case, is that because we did not have the original rent, we couldn't find out where it started? Is that part of the issue?
Well, that would be part of it for sure. Yeah, if you don't have the initial rent, then you're also at a disadvantage.
I thought we did have it because it was pre-Costa-Hawkins, so they had the records.
If they had the records, yeah, well, they might have the records, the city might have the records, but in any case, with respect to your question, I don't think that was an issue. And I don't, I can't come up with a case off the top of my head, but I think what you're describing has occurred.
Thank you.
And Mr. Chair, I'm sorry, very quick one. In regards to that question, I think when the examiner determines the MAR, there are two components always to adjust the rent, to determine what's the MAR, and also to see if there is any amount of reimbursement that the tenant will be entitled to. So you cannot really separate these two things. If the record is not complete, the examiner cannot really make that determination just based on the calculations of the MAR and leave out the possible reimbursement. So I would say that if the tenant comes up with additional record, they may refile, as the legal counsel mentioned. Thank you.
Yeah, question. So kind of carrying off what Commissioner O'Keefe asked, so are you saying that if we know those components, we know the starting rent, we know how much the AGA is each year, we would be able to calculate a maximum allowable rent, because it wouldn't be a maximum allowable rent necessarily, but we would know if it exceeded that number. Doesn't necessarily mean it would be a reimbursement, but we would know if it exceeded that.
That calculation could be what the theoretical absolute maximum amount could have been. You know, I'm wary of calling it the MAR because it's not.
Yeah,
but,
because
yeah.
I understand that, because the MAR is based upon what was demanded.
The
not
MAR is
what-
the legally established rent. But also, I think there was another issue in this case in that the records were not complete, not just the records of whether or not there had been implementations, but the tenant didn't supply payment records. So that's a necessary component too, absent a waiver from the landlord.
But just to go back to, so my question is, so if we can establish that amount, and whether it applies in this case or not, whether here the tenant paid more than that amount or not, if the tenant did pay more than that amount, if we added all those up, there would be a problem there, right?
Then in that case, the hearing examiner could potentially make a calculation.
If both sides proved that they paid it and everything.
If all the records were provided, I mean, the records of rent paid were provided. But like I said, not having calculations in front of me, I can't say whether that would apply to this case or not.
And I don't believe that there's any evidence that the hearing examiner made that calculation either. Because if, as in this case and in past practices, the determination is made immediately that she's unable to reach the MAR because of this missing information. And I've always wondered why it is that we couldn't at least find out the hypothetical maximum. Is there any reason why that you can think of that we wouldn't be able to use that number if it applied?
No?
Thanks.
But how can we hypothetically calculate the MAR by applying annual?
It wouldn't be
general-
calculating the actual MAR. It's just, I think if I'm understanding correctly, it would be to compare what rent is being paid today with what the potential absolute maximum could be as of today if all of the AGAs had been applied. Is that my
Yeah,
understanding?
correct, but we should save that for deliberations probably, but during that time I can flesh it out more.
So then the question would be, did the tenant provide rent increase notices in order to apply?
No, I mean, that's the issue in this case, is that neither party presented.
Not just the proof of payment, but also there is no rent increase notification?
Right.
Okay,
Right.
thank you.
I have one more question for staff. There were a couple of exhibits that were referenced as exhibits or in the body that I did not see in my packet, and maybe I'm missing it. If somebody could tell me the page numbers they're on, if I am. It says on page 99 of the packet that there is a letter from Bank of America and a canceled check. Exhibit 11, it says, are emails concerning rent packets. And then there was also a reference, I think, that the tenant had to the landlord's own documentation on rent payments. And I didn't see any of those Bank of America records, and I'm wondering if staff or anybody else could point me to where I might find them.
What page are you referring to?
Page 99, there's the itemization of the exhibits, and at the top of there, I'm not seeing any Exhibit 11 or Exhibit 12. In my packet, I couldn't find any letter from Bank of America, any canceled check, or any emails concerning rent payments, but maybe I missed them somewhere, because they're not labeled.
We're looking at the case file now for you.
Thank you.
Perhaps, just for timeliness, if the commission wanted to proceed forward with some of the testimony, we could provide these pieces of evidence
I had a
before
couple
your
questions for
deliberation.
staff before we proceed. Maybe, I don't know if this is a Jonathan question or Peter question. Who is generally responsible for prepping an apartment for painting, for covering or moving any personal belongings? Is that the landlord or their painter's responsibility, or is that the tenant's responsibility?
For the smaller items, it would be the tenant's responsibility. For the larger items, it would be the landlord's responsibility.
And then just in general, if there were damaged items for any kind of work, Would I be correct in saying that that would not be something remedied under the rent stabilization ordinance? That might be a different legal avenue, but not through rent stabilization department.
There's no remedy through the RSO for that.
And then on page 22 of our packet, the issue was raised about notices being sent to a Linda Levin or 1009 Sweetser LLC. We know that, for the record, that Mr. Madoff, I'm sorry if I'm butchering the name, is a member of that LLC. Do we know if Linda Levin is, or is that an irrelevant question for the proceedings tonight?
I'm not aware, I'm not sure what the relevance would be,
Sorry?
but I'm not aware of the membership of the LLC.
So would it make any difference since the letters were addressed to both the LLC and to her? Would our bases be covered as far as service?
Oh, if the LLC is the owner, then that's who needs to be served.
Okay.
So the LLC, that would be satisfactory.
Thank you. Oh, and sorry, one last question. On page 103, the hearing examiner's decision, do we know why she ordered the painting to take place except for a portion of the living room? It seems odd to exclude basically one wall of an apartment.
My recollection is that that part had been painted within the last 4 years. There was a small portion of the living room that had been painted.
Thank you.
Commissioners, any further question for staff?
Oh, I'll just mention the page on which the other thing I referenced was. On page 24 of our packet, finding 22, this is the letter from Ms. DeSanto's attorney, I believe. It says that Ms. DeSanto presented a spreadsheet of her rent paid and supporting documentation, including pages of the landlord's internal rent papers. I also didn't see any internal landlord rent papers, so I don't, this isn't the list of exhibits, but I just wanted to flag that I don't see that anywhere in the record. But if anybody found it, let me know.
Thank you. Commissioners, I'm just giving you some time to collect your papers and thoughts if you need it before we move on.
Okay, and Celeste is making some photocopies of the stuff so we can proceed and then have the
Thank you very
additional
much. Great.
documentation later if we want.
Perfect, thank you. Commissioners, give me the high sign when you're ready. Fine, very good. So we'll move on to oral argument. For the parties tonight, because you both filed an appeal, you both will have an opportunity to speak and present your arguments, and then you both will have an opportunity to rebut. So in that, you will have a total block of time to speak of 5 minutes. Before you start speaking on your initial oral argument, please let our secretary know, or our staff know, how much time you would like to allot to your first opening argument, and then how much time you'd like to leave for rebuttal. We may have to wait a little bit for Celeste to do the timing. Do we need to wait, Peter?
I have a question. So the process you just described, they each get 5 minutes for their rebuttal, or they each get 5 minutes
5
total?
minutes total.
Question, I can do the timer. Is it split or is it just a straight 5 for each?
Split. It's their choice. So they can
Right.
say, I'd like 3 minutes initial and save 2 for me. Yeah.
Staff is ready.
Okay. Both do, yeah, because both filed an appeal. So on my paperwork, our landlord is mentioned first, Spencer Madoff. So we'll begin with the landlord or their representative. Please state your name and your time requirement for your oral argument.
Thank you. My name is Daniel Costas. Thank you for this evening. I'm going to go with 3 minutes and reserve 2, but I guess the stop clock will tell me how poorly I speak or how quick I speak. Good evening. I want to address just a couple of issues. I see that on our page 17, on the appeal to the commission, we cited an additional rent increase notice that was sent after the tenant had filed the appeal. That was not referenced in the determination. Our client's concerned that the subsequent rent increase with the hearing determination as to the MAR, or the lack of MAR in this case, precludes us from referencing that initial or the subsequent rent increase that occurred in September. That's our primary concern. Second to that concern, and I didn't bring it up because it did not show up in our information, although I did see it in the summary by staff. I want to draw the court, I'll say the court because I'm used to saying that, so I apologize. Page 12 of the staff recommends that there be a $3 decrease for what is believed to be mold. I do want to point out on page 30 of the packet, there was an inspection done by Eugene Alpers, Senior Code Enforcement Officer, done on April 20th, 2018, not a month before the appeal or the rent reduction. And nowhere in here does he cite anything related to cabinets, painting, plumbing, nothing. I would think that a person in his position would have listed all the things, especially those things that appear to be pretty obvious, and therefore I don't believe that our client got sufficient notice of those issues as it relates to the April 20th, 2018 letter from Mr. Alper. There was mention made about painting in the kitchen or painting in the living room and half being painted. That relates to Mr. Alper's number 1 item. It says an unpermitted partition wall in the living room, and the testimony at the hearing was that that wall was constructed by the tenant without the landlord's permission or receiving or gaining any permit. So as part of the tenant's remediation, after they were served a 3-day notice, the tenant removed the wall. However, the third part of the installing a washing machine was not complete, and nor was there a permit pulled. Quickly again, I don't see that the city inspector on page 52, this relates to the cabinetry. I believe the inspector came out in October 29 of 2018, and he's done an inspection and evaluation of the cabinets. On page 51, he says no black material observed. 52, he says that there's a 3-inch spot on the outside of the door and doesn't reference any of the black spots. I don't see why the staff had determined that that was an issue.
That is time, just so you know.
Thank you.
You'll have 2 minutes to rebut. Before you leave, commissioners, do you have questions? Not at this time?
Yes, you had mentioned that the report on April 20th, 2018, that you didn't have notice. Could you repeat what you said there? I think that the page I was looking at was not the right one. I want to make sure.
Page 30 of the booklet is a letter from Senior Code Inspection Officer, Enforcement Officer Eugene Alper. Item 1 was the unpermitted partition. Item 3 was unpermitted installation of a washing machine. Earlier, you were talking about how a living room could be partially painted and get a reduction for the other. It was the tenant's testimony at the hearing that she had installed a partition wall, and as part of her remediation, she removed the wall and had to repaint. So to that extent, it was partially repainted sometime shortly after April 20th.
Okay. And I have another question. Were you at the hearing examiner
I
at that
was.
hearing? Do you know if she or he asked if each AGA was implemented each year?
No,
That question was not asked?
no.
Okay, thank you.
The issue in that was, it was the tenant's application that it was an illegal MAR, and none of the evidence that she supported either an illegal increase or an overpayment of rent. And so the hearing officer determined that she didn't meet her burden.
Okay, thank you.
I had one question. Could you clarify, you mentioned the notice to, or the AGA additional document that you submitted with your appeal. What were you, I didn't understand your point on what you were trying to explain there.
I lost your question.
So you started your remarks with saying that along with your appeal letter, the landlord submitted a annual rent adjustment for, and then wanted to clarify that that was so you could reference another, like September? Or,
No,
I didn't understand the point.
my only concern there was that at the time that the hearing officer made his determination was based on the facts when the application was filed. And she referenced a 2017 MAR, or I forget what you call it, annual allowable increase. But that doesn't make any reference to the subsequent annual increase that was implemented in September. So even though she says the MAR may she only had reference to what was filed at the time of the appeal or the hearing determination or the rent reduction, but not a subsequent rent increase. And my client was concerned that the MAR would be based on the 2017 and not the 2018.
Thank you.
I do have one question. When you were discussing the kitchen cabinets and the fact that Inspector Alper did not find any or did not list any mold, black spots, and whatnot, how would you square that with, in staff report on page 13, the fact that there is a mold inspection report by an environmental microbiologist that found that there was visible mold and fungus under the sink?
Right, if you look at page 29 of the staff report, you'll see what I think the staff was referring to. It says observations, aging cabinetry, visible mold, and fungi under the sink. The city inspector, Senior Alper, didn't find anything like that, and I point out that the inspector that came back in October didn't find any such thing either. I think what he found was there's an approximate 3-inch spot on the outside of the door of the cabinet. Re-inspection showed no mold anywhere. So it's our position that Senior Inspector Alper didn't find anything, and the subsequent inspection found nothing of the sort, especially not under the sink.
So you would argue just for us to disregard this, or that this was made in error?
Well, it was either an error or it was there at one time, but got remedied, such that Alper didn't see it, and the inspection on October didn't note it as well.
Thank you.
Thank you, Commissioners. At this time, we'll have Nicole DeSanto, but I believe you're sending a representative to speak for you. So please state your name and speak directly into the microphone, and please allow our staff to know what time break you'll be using.
Outstanding. Robert Stempler, attorney, on behalf of Ms. DeSanto. I'd like to go 4 minutes, 1 minute, please. Essentially, ladies and gentlemen of the commission, I'd like to start with the MAR, in that Ms. DeSanto has been incurred, at least on 2 occasions, to pay the rent twice in a particular month because the landlord claims that they didn't get the rent. But in fact, Ms. DeSanto paid the rent, and the manager either pocketed the money or somebody working for her, like her boyfriend, kept the money and somehow managed to take the money out. So Ms. DeSanto had to go out and get another check to avoid a 3-day notice, after getting a 3-day notice, to avoid being evicted at that time. Those occurred in February 2014 and November 2016, and Ms. DeSanto presented the evidence and could share the evidence again with the commission or with the hearing officer again if necessary. She has the checks, she has statements going back 7 years. Now, also with respect to the MAR, I'd like to stay on that for 1 more second, hopefully less than 4 minutes. The fact of the matter is there have been no proper notices of rent increase, except in 2017. That was presented at the hearing with the hearing officer. The landlord presented no evidence of presenting a rent increase, except we presented, Ms. DeSanto presented the 2017 notice. There's been no evidence of any other proper notices. Therefore, it is appropriate for the hearing officer and the commission to request a calculation going back to when the MAR originally began, because there's evidence in the record of this hearing, as well as in the records of West Hollywood, that the landlord signed, Mr. Medoff signed, indicating the beginning rent when Ms. DeSanto moved in 1994, and then the rent increases for a few years before there was a UD at that time. This goes back to 2003. As far as the mold goes, the evidence is, the weight of the evidence is that there is mold. And we have a microbiologist, Mark Brennan, who has studied and seen the mold. We have additional records of mold, and I'd be happy to give those to this commission as well. I've got 2 copies of a report. But there's also evidence from the city, from the County of Los Angeles, that they put a notice up in December, and the landlord hasn't even addressed that there's mold in the unit, that there's peeling paint in the unit, that there's lead paint that was used in the unit. It's not just because of lead paint protects children. It sure does. It is harmful to children. But the fact of the matter is, when lead paint begins to chip, it becomes crackly. It becomes excessively crackly, and the people living there breathe it. The people living there also may have it on their dishes or in their food, because if you go to this kitchen right now, you'll see on the ceiling that the paint is coming down. So whatever the paint is made of, those chips go into food, go onto dishes that you thought were clean, and it's really a horrible mess. So the $3 amount that is adjusted for rent is really low. To have mold in your apartment, to have walls that are so moist that the paint can't even stay on the walls, and periodically it chips away. Ms. DeSanto has requested numerous times that the place be painted and other things. The landlord does nothing. There's no evidence in the record that the landlord has ever painted this place.
Thank you. Commissioners, do you have questions?
Okay. So I had inquired earlier, as you probably heard, about whether your client, Ms. DeSanto, thought that they might have taken more rent, charged more rent than even would be allowed if every AGA had been taken. I know there's the other issue of whether or not each AGA, which is the annual adjustment that's allowed, had been taken. Does she think that's a possibility, or is that not something that she thinks is a possibility?
So what's the question again?
The question is, does your client think that it's possible that what she was being charged would be more than would be allowed to be charged had each AGA been implemented? So had the landlord, which we don't know one way or another because of the record, but had they each year taken the annual adjustment, does she think what she's being charged now is possibly more than that?
Yes, it should be. If the AGAs were properly implemented by the landlord, it should be 522 and some change, not 554.11.
And you're talking about as of the time of the hearing or as of today? Because there's been one more AGA since the hearing.
It wasn't properly implemented, but if it had been, as of a year ago, it should have been 553.11. It wasn't properly implemented by the landlord. Commissioner O'Keefe.
Thank you.
Thank you.
Thank you, Chair. Ms. DeSanto, she testified at the hearing that that the rent was in the 300s. It was about 350, and this is a quote-unquote rough estimate. So in order for the examiner, and I'm very picky when it comes to the determination of the maximum allowable rent, in order for the examiner to make a decision, to make a determination on the legal initial rent, it must be a clear record. So here we have 300s or something about 350. It's a rough estimate. How can the examiner, what is the rent that the examiner has to use in order to apply the annual adjustments in order to calculate the increase? It's a rough estimate. It would not be accurate. It would not be possible to make such determination.
I disagree with that, Commissioner. In fact, the records of the City of West Hollywood contain the information on when, on the original adjusted rent at the very beginning of the rent stabilization, excuse me. Not only that, but there was a unlawful detainer that the landlord filed in 2003. And it also shows and reflects the rent at the beginning of the lease in 1994, and then the rent that had been added through the adjustments, through the alleged adjustments, let's say, at that time of the unlawful detainer. So that is a record of the City of West Hollywood. And that's also a record that was presented at the hearing. So why it's not in the record, I don't understand. It seems to me that there were a lot of documents that did not make it, particularly from the tenant side, into the record, and were not given the weight that I believe is appropriate by the hearing officer. And I think that I really appreciate that the staff did go through and reviewed many of the things, including the issue about the paint and the mold, because it seemed to have been overlooked and lost in the fact that the landlord has not painted this place since my client moved in.
Okay.
Except maybe partially 11 years ago.
Yeah, I have another question about the MAR. Now, the annual rent increases, did your client mention that their annual increases were imposed each and every year from 1994?
That they were
The rent
properly
increases-
given to or properly served?
Yes.
My client does not contend that.
So there was only in 2017 that was properly...
She keeps a lot of records, and the landlord doesn't seem to have records of these, but she kept the 2017 and has no other record. She recalls that she was told that the rent is going up to XYZ this year, please pay that amount.
So you're saying that the annual rent increases were verbal? There was nothing in writing?
Verbal or
for many
text,
years?
or text message, or maybe an email.
Okay, so
Something of that
but
nature.
She doesn't have a record for it, right? The text messaging or anything. It just, you know.
Sometimes there were 3-day notices if she didn't pay the correct amount because they had increased the rent by text message or email, and then they notified her that she had to pay a higher rent.
But every year. So I'm trying to establish if I am the examiner and I want to really help to establish the MAR, and I need to come up, let's say if we look into the city record and we find something there is maybe a certain amount in 1994, but then to apply annual rent adjustment, I can only do when there is a proper service or if there is a proof of payment to see the jump from one amount to another amount. If I don't have that, if I have gap for decades, I cannot really apply the annual rent increase, assuming there was an annual rent increase in, every year or every other year.
Respectfully, I think that the city of West Hollywood has a law that the proper notice has to be given to the tenant. And if the proper notice is not given to the tenant, then the rent is not increased. So instead of putting the burden on the tenant, the burden should be on the landlord to come forward with this evidence that they have properly served notice of the increase on the tenant, and not make the tenant come forward with the one document that she could find where the notice was properly given in 2017.
What was the method of rent payment for all this time from 1994 until now? Is it always checks or sometimes cash, money orders maybe?
There were sometimes money orders and there were sometimes bill payments done, and occasionally the landlords said that they lost the check, and somebody, even though it was delivered by bill pay from Bank of America or Capital One, it didn't get into the landlord's account. They put a notice on her door and she'd have to send another one, and it was an extra rent that the tenant had to incur for that particular month, even though Bank of America or Capital One said it was delivered, said it was cashed, and the landlord did not cooperate in signing an affidavit of fraud with Bank of America on at least one instance, probably two instances, to help the tenant recover that money.
And the last question, Chair, thank you. Did your client contact the banks to see if she could get the records of canceled checks for those years that could have been submitted to the hearing?
We got the bank statements. Unfortunately, one of the problems with those particular instances is she had to pay different ways to get that money to the landlord. For example, I think that there was one time in which the tenant had to get a friend to pay a check, and she had to pay the friend back. She was out of town.
Okay.
Oh, okay, I'm mistaken, but
Twice with bill to pay and then twice with the check. So I have two of the exact same amounts from the exact same person for the checks at those amounts, which I sent to Judy, and somehow they didn't get into the evidence.
All right.
And
I
can you
stand
just step
mistaken. I
up to
apologize.
the microphone
Thank
to
you.
speak, so that it'll be on the record as well?
I just wanted to clarify that, and I think I have the responses. Thank you.
I think Commissioner Topshian he was clear on the issue, but
Oh, sorry. Hi, I'm Nicole. Yeah, so there's 2 months when I was informing Judy that I had paid 2 times, and I had extensively, burdensomely tried, and I called Bank of America. I sent it to several different managers, and I asked you know, on both occasions, like, that if you could help me with this situation, I could retrieve my monies back, you know, because it's not appropriate. And so then I was never assisted, even though I emailed on so many occasions. And there's 2 different months, and like I said, we got to do a closing, whatchamacallit, with Judy, a closing thing, so my lawyer wrote like a 40-page letter, and he included all of that information, and somehow you guys didn't get it. I don't know why it's not in there.
Thank you.
I
Commissioner,
have it, though. I can send it to anybody, so I can show you that I'm being honest.
thank you. Okay.
So
Commissioners.
you're saying you have 2 different checks from both the month of February and November
Correct.
2017
Yeah.
made out to the landlord?
Yeah, yes.
Okay, we did not get copies of
One,
them.
one is through my bill pay, which I never was reimbursed, and Bank of America can corroborate that because it's the fact. And the other ones would be 2 checks that I wrote subsequently when I was threatened with eviction.
And what did, do you remember what the memo said on them? If it said it was for rent or,
Oh, absolutely. They're both the exact same amounts.
thank you.
You're welcome.
Commissioners, any further question?
So the check that's in question was not a personal check from your account that you could see had cleared your account? Then
Both cleared. One was two were personals because there was 2 different months in question, and then 2 were from bill pay where I had like an automatic bill pay situation where my bank would send a check every month, and both checks were cashed.
and that you have a record of?
I promise you I do.
Yes. So it wasn't a money order where
No, sir.
perhaps you would
No.
not have that. All right, thank you.
Commissioners, are we ready to move on to our next rebuttal? Very good. So now we have 2 minutes rebuttal from our landlord party.
So to pick up on the last conversation that was just had with the commission, at the hearing, the tenant presented a statement, and she claimed that the landlord had cashed the rent twice for 2 months. The landlord had testified at the hearing. He says that the tenant had claimed that, and the landlord's record didn't show any double payment. The landlord, at the time that the tenant claimed that this double payment came through, said, "Provide me whatever evidence you have. If I'm in error, let me know. I'm happy to correct it." But the landlord's record showed no such double payment. At the hearing, the tenant submitted a bank statement from Bank of America saying that they were going to check into that particular check and see what happened. But at the hearing, the tenant didn't show anything that either the landlord cashed both checks or received something via bill pay. And of course, at the hearing, the landlord testified, "If I'm in error, please let me know." That is a statement that they've been having, a conversation that they've been having since the tenant alleged it. And to this day, nothing was ever presented that showed that the landlord cashed the check twice. As to the AGAs, you know, the landlord receives a letter from the city saying what the AGA is supposed to be every year. The landlord prepares that notice and serves the tenant. There was no evidence ever presented by the tenant at the hearing that, hey, I paid too much. Never, not a single, not last year, not the year before, not since the beginning, never saying, I paid too much, this is what it should have been, this is how much I paid. That was evidence that clearly the landlord had served the rent increase notices, or else why would the tenant continue to pay? So that's it. Thank you.
And Commissioners, we have 1 minute remaining for our tenant party for rebuttal.
Thank you. The issue really is with those payments, not that the landlord bank account got double paid, but that somebody in charge in the management office of the landlord at the time was able to deposit the account into their own personal account or cash it somewhere at a check cashing place. I have no idea. And the landlord did not cooperate in the fraud investigation by the bank, which I believe at the time was Bank of America. And as I said earlier, at the previous time, we have two additional reports, one from the County of Los Angeles regarding the visible mold, and also regarding the fact that there's lead paint and peeling paint. And we have an additional report from another inspector, contractor that comes in, who has documented the peeling paint and the fact that the walls have moisture.
Thank you. At this time, Commissioners, we move on to deliberation on this matter. I'm going to start and just be frank. I'm not impressed by either party, to be honest with you. I feel you both came to us with unclean hands tonight. I see a host of issues, maintenance issues with this problem that need to be corrected. I see a lot of general contractor things that you did in this apartment that weren't approved by your landlord. And I feel that what we have in front of us is a big mess that our hearing examiner did a decent job of trying to clean up between two parties that I'm not particularly sympathetic for. I just also want to remind the Commission that we're not a small claims court and that there are remedies outside of the rent stabilization ordinance, as well as health code, remedies outside the rent stabilization ordinance. So I am interested certainly in hearing and being persuaded by discussion on the MAR, but I am more inclined to support our recommendation this evening to affirm and reverse in part. I'm interested to hear Commissioner comments too about the mold issue, just because we have a unpermitted washing machine in there that I don't know what that water's doing under the sink, and two of the mold issues that I saw in the record were under the kitchen cabinets. So that's just my initial thoughts before we get into the weeds here.
I have a question. Can someone point out for me, on page 96, the hearing examiner references the Exhibit 70, Exhibit 4.14. Can someone point that out for me in the packet somewhere? It's the reference to the, in 1984, $262.50 being the rent. Am I not seeing it because it's not here, or is it missing?
I don't think the exhibits are labeled by number in our packet, but maybe I'm missing it. I don't think that I've seen that either, but I'm not sure.
So she references it on page 96 at the bottom. 96 or 98? Yeah, 96.
Exhibits.
Yeah, I'm just trying to find that first exhibit they're listed. And I'm not finding that.
You're talking about for the city's records, the base rent for Unit 14
Correct.
in 1984 was $262.50. Is that what you're referencing?
Yeah.
And then it's footnote 70, I guess, which references Exhibit 4.14.
Oh, but then there's...
1984 Tennessee.
I don't believe we have
That's
that
what
exhibit.
I'm trying to find the document.
But she's from 1994. 1994.
Terry's gonna
What's the reference? I mean, this is not in Tennessee, but yeah.
Commissioner Kirby's, we may have it.
This is before, 10 years before she moved in.
Oh, then what is the relevance?
I don't know.
This is all.
Oh, okay, thank you.
Commissioner Martz?
Yes. While you're looking over that, I'll make a few comments. The mold issue, I think the record supports what the hearing examiner found. As we know, we're restricted in overturning the hearing examiner unless we find certain criteria. I don't think that's present here. I think I do think that is present here with the mold report that's been submitted. We have to weigh Senior Inspector Alper versus a mold inspection report by a microbiologist. I think there is substantial weight to the fact that there was a mold inspection report, and not just that it says, there's mold or whatnot, but that there is visible mold and fungus under the sink. If we had magic powers, we could potentially figure out if the unpermitted machine caused that, but I don't think, one, that's our place, or two, that the record supports us doing that. So I think the mold we should find was there and give the decrease on the mold issue. On the maximum allowable rent, I agree with you that this is a mess of a case. The hearing examiner did the best they could, but without records being provided to us, I don't think the record is sufficient for us to make any changes to what was decided. I think the hearing examiner is correct. We just don't have enough here. Unfortunately, when I prepare a case as an attorney, those bank records are key, because you're going to have the landlord saying one thing, the tenant saying the other. Bank records don't lie.
And
Tenants
actual
lie.
records, not a chart.
Right. Landlords lie, or they tell the truth, but, as much as we knock big banks, their records are pretty decent for us to have an objective standard to go by. So I think that we have to agree with the hearing examiner on the MAR.
On the MAR, I think in any case where the tenant alleges that the amount that is collected could exceed every AGA were it implemented, I think the hearing examiner should calculate what those AGAs would add up to so that we can see. Because one of the things the tenant alleged is that there was excess rent retained. And if she was charged in excess of what she was allowed to be charged, then I think it would be clear that the MAR is lower than it is thought to be. So I don't know if we can remand this case for that issue. I would like to make a decision on everything else so that those remedies can take effect immediately if that's possible. The reduced rent for paint and other things. But that piece of the MAR, I'm troubled that Slush showed me one piece of the record, but I haven't seen the itemized bank statement, so I don't know if what she provided includes the name of the payee or not. If it included the payee in two different amounts in both February and November, I would think we have some evidence that the landlord was, pretty strong evidence, that the landlord was paid twice in both months. She said she was given a 3-day notice in both cases. I don't know why that wasn't requested early on, but I'm troubled that I don't have the bank records here that were apparently submitted. So if we could just throw this back for the entire MAR issue, I would want to if we had that legal thing, that legal option, because first I think that it's alleged that it exceeds every AGA if it were allowed to be implemented.
Yeah, just comment on that. There is one issue, though, with just sending it back to create a chart. That's essentially an advisory opinion. What the tenant asked for is a MAR determination. That can't be made. She also asked for an overcharge determination, and from my understanding is there's an issue with the records as to whether, to showing a full extent of what she paid or didn't pay over the, however many years she's been there. So that's my only concern, is that sending it back is just to create this chart, which could be done by any party outside of these proceedings.
Could we just waive the 6 month on the MAR, and she could reapply brand new, start fresh, and add whatever records she since gathered that she didn't have in the first one, and to make her case for the MAR on
For the MAR issue, yeah. If you want to waive the 6 month refiling limitation, that's definitely an acceptable approach.
You said that that anyone could just do the math for the AGAs, and I've looked on our website and I wasn't able to find anywhere where we list every AGA per year. Am I just missing it, or is it there somewhere, or if they ask city staff, would city staff provide it?
I don't know if it's on a website. I know that I've seen a form that shows all the AGAs that have been permitted over the years. And that information, whether it's on the website or not, would, Peter can confirm this, would be with rent stabilization staff. Yeah, but he's looking at to see if it's on the website.
Okay, if that were the case, if we could provide the list of the AGAs going back to 1994 publicly available so that both parties could do the math if they want to find out if in fact more has been charged than is allowed, then I also would support waiving the fee, because if in fact what's alleged is true, that she was given unlawful detainers, saying that she owed more rent, that she has checks that have her name and the landlord's name, then I think absolutely there would be, absent it being rebutted, very strong evidence that there was an unlawful overcharge, and that's exactly the kind of thing that action should be taken on without somebody having to go to small claims court. But we don't have it in our record here, unfortunately.
I'm going to jump back in. I appreciate that, but our job is not to kind of really direct the applicants or the landlords to how to present their case. We're given a record here, and the record we were given was incomplete. I think that both parties did a relatively poor job of presenting their case and could have done better. There are a lot of things that are missing that they could have gone out and gotten. It's not really, in my opinion, our job to bend the rules to make it easier for them to prove or disprove their case. So I'm not necessarily against what you're saying, but it just sounds like we're trying to make a workaround when the issue is they didn't do their job as best as they could.
I'd say the hearing examiner has pretty wide authority to get information on her own, and I think that our process should be as open as possible to people that aren't savvy and that aren't attorneys and that need help to get their way to justice and need to be walked through it, and that I would like to see that process be something that does assist people so that we can get to that the hearing examiner gets to the root of the truth and applies a remedy if it's warranted.
And I think if I'm understanding correctly, or regardless of whether I'm understanding correctly, what I'm asking is that we simply give them the opportunity to almost like retry that issue because without waiving or waiving the time frame, because not only in this case, that's why I was so surprised when I asked the question earlier to staff attorney, is that the hearing examiner never calculates, even though we have available information of the starting rent and what they're being paid today. I've never seen a case where the hearing examiner has taken the publicly available information that the city offers and adds those AGAs up. That's not going to give us the MAR, but it will tell us if we exceeded the amount. And that's what they're claiming. Well, they kind of go back and forth on it, but some of their claims, and that's what I'm suggesting. I don't know if we'll get a much better, I don't know if a MAR will be determined, but we'll at least know whether the claim, whether she's overpaid the potential MAR would be adjusted, because we know for sure that under no circumstance would she be required or should be required to pay for that amount. That's where I'm kind of going.
Couple of things, Chair. Again, in regards to what Commissioner Kerpes mentioned, so I know that, we remember that from the testimony of the legal counsel, the tenant's attorney, there was a calculation, and they already calculated roughly that there is, the rent should have been $520 something, which means that I assume they had the list of annual percentages that were allowed under the ordinance from 1994. So that's how they came up with the amount of $520 something. So, but what I want to mention is that our commissioners, our job is to determine whether the record before us shows that the examiner erred in her or his findings. And to be honest with you, I don't really see that because, again, as Chair, you mentioned that this is a very messy case and the record is incomplete. Both parties did not do a good job by providing a record for the MAR determination. We're talking about almost 25 years of over 20 years of rent payments and rent increases. So if we just come up with the list of and apply every year the amount, what would be the benefit? So it is clearly a possibility of illegal rent increase here, and nobody's really disputing, I think, among us. There is a possible illegal rent increase, but how it would not be a wise thing to do for us to, or for the examiner just to apply the annual increases, and then if the record will be provided later on, it would turn out that, okay, so these rent increases should have been applied because there were no rent increase notification given at the time. So I don't think the examiner should do a calculation. And I believe, the other party, which is the tenant's attorney or the landlord's attorney, they may apply those percentages to come up with the hypothetical what the rent should be today. And but in any case, if there is a MAR determination, the examiner always look into the two aspects of it, two components. One is that to determine what the rent should be, And the other component, if the tenant was overcharged. Otherwise, what's the purpose of looking into the how much is the rent, how much the rent should be? We already know the tenant is overpaying. But now the next component is how much the tenant should get the reimbursement for overcharges. So because the record is incomplete, obviously the examiner couldn't do these calculations, and therefore this is what we have now. And I agree with you, commissioners, that we can waive that 6-month waiting period. We should do it. And instead of remanding back to the examiner, because there is really nothing at this point for her to do, it's just we can give some time to the tenant to contact the banks or other agencies or parties, whoever involved, to get the best evidence that she could to establish at least a pattern of payments, and for the examiner maybe to come back in 6 months and just, within the next few months and do the calculations. In regards to the other issues, I also don't see that there was an error in the findings of the examiner, although I have to, also mention that in the city of Los Angeles, we have very strict rules when it applies to the maintenance standards, and the landlord should know about it, and that the apartments must be up to code, and otherwise there will be rent reductions and would be penalties for citations issued by the department for the habitability code violations. So I would encourage the landlord to do everything as possible to fix whatever it needs to be fixed in the unit, because the tenant is entitled under the ordinance and the state law to reside in a habitable space. So as for the MAR determination, yeah, as I said, I just would like to waive the 6-month period. Thank you.
I would just add that I think if I had my way, I would really want to remand this case for more clarity. But I don't think that's where we're going. But the one modification that I feel comfortable about would be the waiving of the 6-month time frame.
In regards to the MAR?
In regards to the MAR.
Got it, right.
So I'm going to agree with the staff's recommendation on this, and agree in part and disagree in part with some of my fellow commissioners' comments. Commissioner O'Keefe, I don't think it's the responsibility of city staff or hearing examiner to assist either party in either way with their appeal process. I think that would be showing favoritism. It's up to each party to prepare their case, prevent their evidence without the assistance of city staff. Going through this list, I agree with staff that we can't make any kind of a ruling about the tile flooring because it's covered up with linoleum that the tenant installed. The washing machine was installed without a permit and without permission from the landlord. And landlord is not required to give permission to install a washing machine. It was not a housing service when the tenant took occupancy of the apartment. And from the photographs, not a technical term, but it looks like a really Mickey Mouse installation of that washing machine, which may or may not have caused that the mold. I do think that perhaps our inspector did miss that mold. I'm confident in staff's current recommendation that there is mold that needs to be remediated underneath that kitchen sink. Again, I wish there was more information in the record. On page 86 of our record, it's the tested paint appears to have lead. We don't have any tests in the record that we can look at to say if there was or was not lead in the paint in the unit. As far as the MAR, I find any and all discussions about possible double payments of rent to be completely irrelevant to the MAR determination. It might affect a different determination if there was an overpayment of rent, but not for a MAR determination. I had also had in my notes that I would be in favor of waiving the 6-month waiting period if the tenant is able to come back with concrete evidence of the rents that were paid and any notices or lack thereof. It's not just taking what we think the base rent was, and the AGAs over the years would need to see concrete, bank statements, checks, any form of payment to bring that back, but I would be in favor of waiving that 6-month period as well. So I would be in favor of affirming staff's recommendation with the caveat that we waive that 6-month waiting period as it alleges just to the MAR determination.
Mr. Chair, if we agree on the waiving, then of course our motion will have to include the waiving.
Exactly, and we did this the last meeting too. We just, we'll add a bullet point.
Or
saying
do
that-
we want to determine who is in favor of waiving?
And I'll put my cards on the table and say I'm also in favor of waiving the 6-month reapplication period. By definition, we are the rent stabilization ordinance. We implement the we are the Rent Stabilization Commission. We are already tipping the scales here because we see a public policy in maintaining affordable housing in the city of West Hollywood, and this MAR determination goes directly to the public policy of maintaining affordable housing in our city. And I think that if we do have city records that show us a base rent, if we, if the tenant can prove and show these records, I think that goes to the entire public policy of why we exist. So I'd be in favor of also waiving the 6-month waiver. So with that said,
Do we want to make a motion which would then include the waiving? Is that correct?
exactly.
Well, then I would make a motion based on the record evidence. Staff recommends that the commission affirm in part and reverse in part with a 6-month waiving time frame on the maximal allowable rent. And the facts of the finding conclusion of the law to which the tenant objects, other than the revision to the findings of the facts regarding the kitchen cabinet, staff recommends. So therefore, I ask that we adopt resolution RSC 19-540, a resolution of the Rent Stabilization Commission of the City of West Hollywood, affirming the hearing examiner's decision in D-4347. Is that sufficient?
As amended.
Amended.
Second.
One friendly amendment requested. The overcharges was key to what I thought. We should allow them to, her to file again. Can we add "and overcharges"?
I would agree to the amendment.
So commissioners, we have,
Just ask, I'm not sure where the
I think I seconded.
overcharge is part of the original hearing or not. Can staff verify?
Yeah.
Because if they were not, I don't think we should waive that.
Yeah,
It was, okay.
but
thank you.
that's fine.
So-
They can so the motion is that the prohibition on a 6-month, of filing within 6 months is waived for MAR and overcharge.
Yeah, and that will include for these overcharges from 2017, right? Not new overcharges. She could file again
You can
with the
yeah.
paperwork for this. Perfect. Thank you.
So how procedurally, say we pass this, procedurally, how does the tenant go to a hearing examiner and ask for overcharges of rent when, like, as you said earlier, the MAR is not actually going to be able to be determined, but we will know what exceeds the potentially hypothetical allowable MAR? How was the tenant ask for that? Because I don't know if the process allows for that.
Well, from what I understand, the commission is giving the tenant an opportunity to come back and with additional evidence to establish the MAR. Whether the hearing examiner addresses the issue that you raised tonight will be up to the tenant to raise with the hearing examiner.
So the tenant needs to make very clear that they're not only asking for the MAR, they're asking, okay, if we can't figure that out, we need to set that aside and we need to determine what would be the highest allowable MAR under my circumstances, and can I present evidence that shows that I paid more than this hypothetical high number, right? And then the hearing
That's why it
examiner
would
would be able
behoove them to make those calculations, and as stated, that information would be made available to them if they need it.
Thank you.
Mr. Hollop, can you repeat that part about the reimbursement from 2017?
There's no prohibition on going back and seeking the overcharges for any period in which there was an overcharge, because there's no final decision made here. There's no administrative precedent prohibiting a new determination made. It just couldn't be made. So if the new information is available and it provides the hearing examiner with enough information to make a decision, going back whatever period, that can be done.
Okay, I just wanted to clarify that. Thank you.
I just wanted to make to kind of clear that if we pass this amended resolution, that if the tenant is unable to produce evidence, that more than likely not going to bode well, that we are asking specifically for specific evidence of the payments over the tenancies.
We're just sending it back is all I thought we were doing. We're waiving the 6 months.
Right, I get what you're saying. If we see this again, Commissioner Bergstein, everybody knows what we're looking for.
We're looking for payments that have the
Exactly.
landlord and the tenant's name twice in the same month, or calculations that show what the AGAs would have been, where they implemented each time, and then comparing those to what's actually charged. And if it's a higher amount, when you add all the permissible AGAs than what was actually charged, then that would be very compelling.
I get it. So we have a motion on the table. May we have a roll call?
Commissioner O'Keefe,
Aye.
Commissioner Kerpes,
Aye.
Commissioner Maggio,
Aye.
Commissioner Martz,
Aye.
Commissioner Topchian,
Aye.
Vice Chair Bergstein,
Aye.
Chair Charity.
Aye. Thank you very much. The motion passes. Parties, please address staff with any questions you may have about tonight's proceedings, and we'll be moving on to, oh, yes, Commissioner Maggio has requested 3 minutes just for a human break. Okay, Commissioners, if everybody's ready, we'll move on from 9A to 9B. This is Appeal D4384. The address is 1301 Havenhurst Drive, Unit 208. This appeal was filed by both the tenant and the landlord, so I'm going to check for the parties. Our tenant is Holly Nakamura. Is Harley present? No. The landlord, Jeff Miller. Is Jeff present, or is representative? Okay, so a representative for the landlord's present. At this time, we'll have a report from staff.
Thank you, Chair. Holly Nakamura, a tenant in Unit 208 since 2000, filed an application for a rent adjustment for common area issues involving exterior lighting and exterior paint. The hearing examiner awarded rent reductions in the amount of $12 for broken inoperable lights and $3 for the failure to paint an exterior wall per the maintenance standards of the Rent Stabilization Ordinance. Both the tenant and the landlord have appealed. The tenant appeals the issue of the exterior paint and asks the commission to allow the submission of new evidence. The landlord has appealed on both issues on the following grounds: that the tenant is not authorized to bring an application on behalf of the other tenants, and 2, that the hearing examiner erred in ordering a rent reduction for the paint. Staff recommends that the commission affirm the hearing examiner's decision. The tenant is prohibited from submitting any new evidence because this evidence could have been submitted at the hearing before the hearing examiner. With respect to the landlord's appeal, the RSO is clear that a tenant may file an application for common area issues on behalf of other tenants, and that those tenants are then deemed applicants as well. In addition, the landlord's argument regarding the paint lacks merit and uses an incorrect analysis of the basis for the rent decrease. The hearing examiner ordered a rent decrease for the exterior paint because the landlord failed to adhere to the maintenance standards of the RSO, not the alternate grounds of a substantial reduction of a housing service. I'm available for any questions.
Commissioners, questions for staff?
I have some. First of all, if I read it correctly, I understand the hearing examiner considered the wall to be an interior wall, but staff considered it to be an exterior wall in its report. Is that correct? And could you explain the thinking of why it would be exterior wall versus an interior wall?
It was common. It was considered common area exterior.
Staff, or the hearing examiner's statement on
Can
that,
you
I
show
think,
me where
was
that is?
on page 147, where it was called an interior wall. And I think staff, and the difference, of course, is how frequently it must be repainted. So yeah, at the top of page 147, it says tenants are entitled to a rent reduction if the landlord does not paint the common area interior every 4 years. So my thinking was that that was what the hearing examiner considered it, but it looks like staff disagrees and considers it exterior.
That could be a typo. You're talking about at the top of page 124, the tenant appeals the issue of the exterior paint and ask the commission to allow the submission of new evidence.
So Commissioner, you believe that the exterior lighting and garage wall, it's basically the page 147 that references a different wall?
Tenants are entitled. Well, the heading on 146, the bottom of 146 says, the tenants are entitled to a rent decrease based on the painted garage wall. And then it says, tenants are entitled to a rent reduction if the landlord does not paint the common area interior every 4 years. And in the landlord's appeal, they referenced 4 years as well. But then in the resolution we have before us and in the staff's report, they reference exterior wall. So I just wanted to clarify, since were we to agree with the decision, it has a significance for how frequently this wall must be painted.
I'm sorry, could you just point me to what you're referring to in the resolution, just so I know where it might be incorrect?
1 second. So, page 1 of the resolution, at the end of the first paragraph, it says $3 for failure to paint an exterior wall.
Mm-hmm.
And that was also in the staff report before we got the resolution. I recall reading that. So it seems like it wasn't a typo from staff, that staff consistently considered it exterior.
I think that's a typo. I think that would have to be correct. I don't see an analysis, a change in analysis, so I think it should say interior, because that was the finding, that it was an interior wall. So I think that's just an error that we can correct.
I mean, the reduction in cost might be the same either way, but
The reduction would probably, it would be the same.
But it matters
Your
what it
analysis,
says.
correct, that if it were actually different, the analysis would be different, but I don't see anything that would indicate that staff's analysis is based on an exterior wall. That just was a typo, I think.
Commissioner O'Keefe,
It's still somewhere else.
Difference. The tenant is alleging it has been painted since the beginning of their tenancy was 2000, so that was, we're in 2019, so we're well past both the 4-year mark and the 7-year mark. So would that
Well, that's
be that
true. I think
decision?
it's important that we're careful in what wording we use, because if we've decided that it's an interior or exterior wall, that will dictate how frequently it must be painted.
I can appreciate what you're saying. I can show you right here. In the resolution, the drafted resolution that we may or may not approve, it's referred to as an exterior wall and just referred to as an interior wall in their discussion. So Commissioner O'Keefe is just pointing out that in our resolution, we'd have to change that word to interior. Is that, am I following you
Well, we
correctly?
just have to decide which it is.
Well,
That's
yeah,
the
and
question.
it seems as though that that they are operating under the body of law, that this is an interior wall, is what I see in the record.
Okay. Then I have another question. So the landlord brought up the 1991 investments case, and staff's position is that that's not applicable. In that case, there were about 4 different things that tenants said were removed, and the court said essentially that they weren't significant enough to be a substantial housing service that was removed. One of those was carpeting in a common area that pets had urinated on, and it was replaced with concrete in a common area. And both the Rent Stabilization Commission and the hearing examiner had ruled that the carpet did have to be replaced. And the landlord said, well, the carpet has been peed on, it's going to be peed on, it's better to have concrete. And ultimately, the court agreed. And why I bring this up is because the carpeting is also in that same section for repainting. It says that carpet must also be replaced every, I think it's 7 years. So I'm wondering about staff's position, how that 1991 investments case interplays with this. If I think staff's position was it doesn't matter if the condition's materially worse or not. The question is, does it have to be repainted every 7 years? And the landlord's position was that it could just be sandblasted instead, or that's what was necessary and would have it up to standards from what it was. So if you look at 17.56.010 maintenance standards, section 2 says that carpet of comparable quality must be replaced every 7 years too. So that also is a maintenance standard as well, yet our decision was overturned in the past and found that concrete was okay. You can totally get rid of carpet. So I'm wondering why you couldn't get rid of paint and sandblast it and just have cinder blocks if that was just as good as it was previously. So what would your response be to that?
My recollection is that in the 1991 case, the issue was whether or not that section of the common area was de minimis or whether or not. I mean, so it was a different housing service, really. It was a small area. The court considered it insignificant, I think, but whereas in this case you've got a complete wall that's been painted, so they're distinguishable. That would be the difference I would see.
I guess my thinking was, we don't know if, setting aside the question of was it de minimis or not, if it were only a de minimis reduction on a painted wall, does it per se have to be repainted every 4 or 7 years, notwithstanding the 1991 case? If it was just as good, if they decided to do wallpaper instead, say, and not repaint it. The question is it a per se you have to repaint it every 4 or 7 years, or could you replace it with something that's just as good as what it was before? So what the staff report said is there's 2 different standards. There's the reduction of housing services, and there's the maintenance standards. And the staff said essentially if the maintenance standards have to be upheld, then you have to paint it no matter what. You have to recarpet it no matter what. But in 1991 investments, they said, no, you don't have to recarpet it no matter what, even though that's under the same section of law. So my question is, are we not still bound by the general thinking of it's got to also be a substantial reduction in housing services, or could there be something that was the equivalent of what's provided that's just as good that was not necessarily paint, like wallpaper, or if the cinder block was as good as the paint was initially?
The issue before the hearing examiner was whether or not the minimum maintenance standards had been met, and they hadn't. So that's really all that the hearing examiner should have been addressing. I think it goes beyond the scope of the proceedings to hypothesize what else they could or could not do to that area. But I'm not sure. Is that answering your question or not?
We can just move on for now. Save
Okay.
more discussion for deliberations.
Yeah.
Commissioner Bergstein, I think you had a question.
As one of the non-lawyers, I want to thank Commissioner O'Keefe for bringing up the 1991 investment. The landlord also brings up the Santa Monica Properties versus Santa Monica Rent Control about the standing of all tenants who had not essentially physically opted in to a hearing. Can you explain in layman's terms to me how that case does or does not pertain to the issue in tonight's hearing?
Well, in that case, the issue was whether or not the rent board could initiate a rent reduction case for individual tenants. And obviously Santa Monica is operating under a different set of laws, and their laws did not specifically allow for that. So the court was looking at a different city and a different ordinance. Whereas in West Hollywood, the rent stabilization ordinance specifically states that a tenant can file a case on behalf of all other tenants, and that's in fact what happened. This was not initiated by the department or the city. So that's the distinguishing feature and why that case is not applicable here.
And that is consistent with all other cases we had before, and based on my recollection, we had cases when we considered that ordinance that, a tenant filed a complaint for the carpet inside the common area, and that reduction applied to each and every tenant in the building. So that is consistent with this decision with what we heard before.
Well, that's true in the 1991 investments case. The court overturned in part the decision applying to all tenants when it was housing services, because they said you have to prove that for each individual tenant, the housing service has diminished since they moved in. So we can talk about that. I guess that's not really something we need to discuss.
Yeah, because
right
we're
now.
still in questions for staff, and if we don't have any further questions for staff, we can move on to our oral argument. Okay. I believe you're the building manager. You can come forward. When you speak, please remember to state your name, and you'll have 5 uninterrupted minutes to speak. Please know you can't present any new evidence to us.
1301 Havenhurst Drive, and I represent the owners. So the initial, it's just going to take probably a few minutes. I'm not going to spend a lot of time since the tenant is not here, not present. One of the questions or comments, I was either trying to do we were to sandblast the walls or paint it. At the end, the owner just decided to paint the wall, and that was the confusion whether we needed to paint, the walls every 4 years or every 7 years, since we didn't have recollection on when was the last time that was painted. I took over management of this building 2 years ago, but I couldn't find any records on when that particular wall was painted. So neither the tenant, and we know that she moved in 2000, but we didn't have any recollection of that. And the owner just decided to go ahead and paint that. But I wanted to, I don't know if she wanted to paint the entire garage, but she presented more evidence to the city that she wanted more walls painted. So what the owner did, that painted that major wall that she stated at the beginning, and then just decided to paint other 2 minor walls that were there, because she could present the same case again, let's say a week from now or a month from now, and just go over again. So I personally decided to just paint those 3 walls. I have evidence as well, because I wanted to, I can't present that, but they're already painted. Also, we fixed the lights in the exterior as well. Back in January, I presented that to the city, and since we were still it was still the process that it was not deliverable, I guess they denied the light application. Let me get the form, sorry. The compliance determination request form for the lights, I submitted that last month, and they told me that they were going to wait until the decision of this last hearing was made to be able to take effect. And that's why I brought photos of the areas that were painted, and I'm going to be presented to the West Hollywood tomorrow morning, just so you guys know, and should be done.
Has been done, and is filing a compliance?
Right, but as of this stage,
It's not.
We don't, exactly. So we don't have that on the record, so we have to do our job, and then they do their job.
All right, so he understands
Yeah.
how that will go then.
Exactly, right.
Thank you.
So is, the landlord's not dropping the appeal though, right? It's still, we'll have our decision.
What he's
and then-
doing, there's the back and forth, and that's why we decided to, paint those walls just to get rid of, let's say, the appeal. Pointing those things out in the city of Santa Monica, and, that's gonna be the back and forth, with our legal department, and just decided to just, throw it off.
Thank you. Commissioners, deliberation.
I didn't hear any, correct me if I'm wrong, but I didn't hear any evidence that we should do anything other than what the hearing examiner has done, right? Okay, thank you.
There's a question of if it's interior or outdoor, exterior. I was gonna, when it looked like we might be challenged in court, and there was this 1991 investments, I did have some questions about whether or not, but it doesn't look anybody's even making the case anymore that it shouldn't be painted, so I'll drop that. But I do wonder for the question of exterior, interior. For interior painting, it's every 4 years, and the idea of having to paint the inside of a garage more frequently than the facade of a building, I feel like the word interior was meant to be hallways, places that people really use, not cinder blocks inside of a garage. So I actually think that exterior, which was the frame wording used, even though technically a garage isn't exterior, it seems like it would be more appropriate in this case than interior.
Yeah, I have to agree that I think I've seen some very nice garages in West Hollywood, and they, have a reflection on you when your guests arrive, and I consider them interior.
I just, well, although I agree what you, Commissioner, said, but I'm going to support the staff's recommendation because I don't see really the examiner erred. The findings are correct based on the record, and I'm going to support the staff's recommendation.
Just to clarify, you'd have to amend the resolution to change the word exterior to interior if you want to be.
With that clarification, it wouldn't hurt. I agree. It's just, but in totality, I'm just ready to support.
Okay, I tend to think it's more appropriate to use the exterior standard, so I wouldn't vote for it if it uses the word interior, if it's amended to use the word interior.
What did the hearing examiner use?
So you'll see on our draft resolution under summary, the first paragraph, the second line of that first paragraph under summary, the very last word, exterior lighting and exterior paint. And we'd want to change that instead of exterior paint to interior paint.
My question is, what did the hearing examiner use, though?
Hearing examiner used interior.
Interior, okay, so we want to...
I would
it's
be in
4 versus
favor
7
of
years.
interior. I think a garage can go either way, but again, our place is not to, change the wording, and I think if we go by the plain language, interior common area, a garage has an interior and an exterior. The ordinance is relatively clear. I mean, we can debate whether that's fair or not, but that would be my reading of it, and I think that's what the hearing examiner found, and I don't see any error necessarily in that.
Well, it actually says it twice in that paragraph, so you might just want to say amend it to globally say interior in case I didn't catch everyone.
Sure. And then I would just like to touch real quick, not that there are parties arguing on it, but I extensively read the cases that were cited here, and I want to touch base real quick on the question you had about why Santa Monica doesn't apply, because I think it is actually a distinction and it's important. Is our process is better, in my opinion, because it's better for us because it protects us legally in that a notice is sent to the tenant saying, hey, we have this application being filed, you can opt out. So by not opting out, they're basically opting in. Santa Monica never had that process. And the Santa Monica case, the reason they lost wasn't because it was unconstitutional or anything like that. It's that their rent stabilization ordinance didn't permit the staff to do that. We have a very clear law that allows our staff to send out that notice. So I think we're better protected, and that's why this case that's cited here, there were several, but the Santa Monica Properties versus Santa Monica Rent Control Board is significantly different from the facts here and wouldn't control, in my opinion.
Agree on that.
I would be voting in favor of staff's recommendation, my fellow commissioners, and Commissioner O'Keefe, I had the same thought that you brought up about the difference between the maintenance standard, whether the wall could be sandblasted, which would be different than painting it, as it was in the 1991 case where the landlord removed the carpeting and left concrete. I don't know if it's relevant to tonight's hearing, but I think maybe we could have a discussion from staff at some point about if there's any latitude that the ordinance would allow for, I guess it would be a change almost in a maintenance standard if all parties were to agree that change in maintenance standard would be acceptable to all, but not really pertinent to tonight, but perhaps for another night for a discussion.
Motion, if you are. Yes?
Yes, I'm ready, but just so you know, the paint is referred to as exterior paint a few times in this resolution. So when you make the amendment, you may just want to make it generally speaking that when this resolution refers to paint, we're referring to interior paint, interior common area paint.
Why don't you make it that?
Sure. So I'll make a resolution adopting Resolution RSC 19-43, a resolution of the West Hollywood Rent Stabilization Commission affirming the hearing examiner's decision on D-4381, address 1301 Havenhurst Drive, Unit 208, with the amendment where in this resolution it refers to paint, that it will refer to interior paint and will strike exterior paint throughout this resolution. Thank you, Secretary. May we have a roll call?
Commissioner O'Keefe?
Nay.
Commissioner Kerpes?
Aye.
Commissioner Maggio?
Aye.
Commissioner Martz?
Aye.
Commissioner Topchian?
Aye.
Vice Chair Bergstein? Aye. Chair Charity?
Aye. So thank you very much for your appearance tonight. Thank you for taking care of these issues, and any questions, please refer them to staff. Okay, commissioners, that's it for our appeals. On item 9, we'll move on to item 10, public comment. And we do not have any further public comment this evening. I do know we have some commissioner comments coming up, so we're moving on from item 10 to item 11, commissioner comments.
All right, so I have a few. The second appeal brought up some issues that I wanted to raise. I haven't been on the commission that long, so I don't know if we've ever been notified before when one of our decisions was overturned, but I was surprised to find out about that through appeal. And so I was hoping that we could be notified first each time any of our decisions are overturned, so we can read those court decisions or at least a summary of them and know what courts are ruling. Second, each time there's any court of appeals in the state or Supreme Court decision on rent stabilization at all, I think we should be knowledgeable about what courts are ruling on this issue, and since not all of us are lawyers, ideally that would be a quick summary in addition to being sent the case. And then third, I'd love to just see a printout or an email that includes all the key court decisions that we should be mindful of when we're making our decision, like any key decision. The Westlaw had notes for anything that's pertinent to especially the question of habitability standards or whether or not housing services are decreased. So I don't know the way to do that, if I can just ask staff and they can respond during staff comments, or if it should be actually a motion that we debate at a future agenda item in another meeting. But that's the first thing.
Commissioner O'Keefe, can you explain number 2 again for me? I didn't fully grasp the idea.
I'd like to know every Supreme Court or Circuit Court, Court of Appeals decision on any rent stabilization issue. So first, when we personally are overturned, but then if there's any court decision on rent stabilization, we should know of it so that we're aware of what's happening, because the same reasoning could apply to our own ordinance. So just so we don't find out about it by appeals that mention cases that we haven't heard of.
Can you explain, I'm just playing devil's advocate a bit, can you explain how that relates to our rent stabilization ordinance? Because if we are looking at decisions that are decisions made on, other jurisdictions' rent stabilization ordinances, then how would that benefit us from knowing if those decisions were like, if they were overturning something in Santa Monica or San Francisco, for instance, what would be our benefit to knowing that?
So it depends on the specific ordinance, but maybe staff could include a little note of we don't think this is applicable or this could potentially be applicable. But in some cases, the what cities are allowed to do for rent stabilization is limited by state law. You're only allowed to have a rent stabilization ordinance for certain purposes. So for example, that Santa Monica case that was cited, well, it did interpret Santa Monica law. It also cited another Court of Appeals decision that discussed what types of things could be services. And I think that was the luxury spa one, where the same reasoning was used in the 1991 case that our own court that makes judgments that we have to abide by, presumably, or that overturns our decisions or upholds them. So basically, just to know the reasoning of any decision and challenges that are out there. So some will be applicable, some may not be.
Commissioners, thoughts, questions?
So I don't know how to proceed. If I guess I could make a motion unless. Oh,
Commissioner Bergstein had a question for you. Oh, you can finish.
yeah. So if staff could just do that on their own, then that would be great. If not, I guess I'd ask for a motion in a second and all of that.
Commissioner Bergstein.
Two things. One, in your packets, I included I cut and pasted a copy of an article. Actually, it was in the Palm Springs newspaper this morning, and I found it in the LA Times later on, that the appellate court upheld Santa Monica's laws on short-term rentals. The lawsuit was saying that Airbnb should not be responsible, basically, for any units rented that were not registered with the city. And thankfully, at least in my opinion, West Hollywood, we are very strict that no rent-stabilized units can be Airbnb short-term rentals. In fact, I think it is only if you own your own home and live in your home, or if you own your own condominium and live in the condominium with the permission of the HOA, are you allowed to do any kind of short-term rentals. So just thought an interesting read, not so much on rent-stabilized housing, but on housing and short-term rentals in West Hollywood. And then second, Peter, I wanted to thank you for bringing up and look forward to a status on the potential grants for property owners for earthquake retrofitting. I have one landlord that calls me every single week asking me for an update, and I just keep saying, not yet. So I think I can say within 30 to 60 days, we may have more information. Would that be correct? Thank you.
So I just had a question relating back to Commissioner O'Keefe's comments. Does staff get reports on court decisions that are related to rent stabilization in the state?
Well, as a member of the LA County Bar Association, I get the daily updates. You know, they're far and few between, but I'd be happy to grab them. And if I'm not here, I could give them to Allison, and Peter can tell you what happened, or I could forward them to you directly.
So we don't need a motion, you just don't mind just sending them if we're overturned or if there's a relevant decision?
I'll just bill you for the extra time, and
okay.
It'll all be fine.
Gracious, thank you.
I'm just kidding. You know, what we can, you know, just want to do it most efficient way possible, but I'll think about it. And
seeing as they're few and far between, it's not putting too much of a burden. If, no.
Yeah, the published cases relating to rent control are, yeah, not that common, but so when they pop up, I notice them, and you know, I'll try to get them to you.
Thanks so much.
And then, I'm sorry, I had a couple other things too. I just was like pausing because I didn't know where to go with that. So one other thing is this brought up that I think it's worth considering having either a standing or ad hoc subcommittee to look through our Rent Stabilization Commission ordinance and compare it to these decisions and just see if anything needs to be changed, and state law. Like I noticed that there's something that in the NOI that refers to how much landlords can be compensated for maintenance, and it's $7 an hour, which is below minimum wage now. And, you know, just looking at the painting standards and really being able to kind of pour through with assistance of counsel court decisions to make sure that there's nothing that should be changed so we're not getting overturned. And it could be that there's nothing, but I thought it would be worth doing a deep dive. So I'd make a motion that for a and I don't really care if it's standing or ad hoc. If it's standing, then whenever there's a decision, it could just keep meeting. As I had asked Peter about how it would work, and if it was a standing committee, then there would staff would add it to discussion on the next agenda item, and the commission could consider recommending to city council to create the subcommittee. So it would have to be approved by city council. If it's ad hoc, it doesn't have to be. So I don't know if there's any second, but I think it's worth personally.
Couldn't we do that more effectively in the study session?
And I have a question, one other.
Let me jump. Sorry. So sorry. Let me jump in and just clarify that what you should ask for this evening is to place it on the agenda as a discussion item. And what we would do is put it on with a clear description of what the commission would be considering, with the potential recommendation that you would either be forming the ad hoc or requesting that council consider a subcommittee, a standing subcommittee. So tonight you wouldn't be able to make that decision of forming, but you could just, as a body, make the decision whether you'd want to discuss it.
That's right, thank you, sorry for that. So I'd make a motion that we consider either ad hoc or a standing subcommittee on a future meeting to review the Rent Stabilization Commission or the Rent Stabilization Ordinance and regulations to make sure there's nothing in conflict with court decisions or other state law.
I would second that as a discussion item.
Can I make a friendly amendment? That we add, in addition to the potential for forming a ad hoc committee or a subcommittee, or that would be delegated to staff to report to us on a routine basis.
I would rather actually have us take an active role, so I wouldn't accept that. I'd like us to use the advice of staff at the subcommittee, but I would like it to actually be the commission members that parse
You're not
through.
willing to have that as part of the discussion?
Oh,
That's what I'm
yeah,
asking
it's
for.
just the discussion. Okay, sorry, yes.
You can bring that up in discussion if we even get it on the agenda.
Good call.
Okay, so the friendly amendment was accepted. Do we have a second?
I would accept it.
I second.
I thought I had second.
Well, he made the
Oh,
amendment,
she
and so yeah, that's all. So, Secretary Brino, can we have a roll call?
Commissioner O'Keefe,
Aye.
Commissioner Kerfees,
This is put on the agenda, right?
Put on the agenda for March 28th.
God, not for the 28th.
Well, that's when
No,
we have
can't.
time.
Commissioner Kerfees. I'm sorry.
Aye.
Commissioner Maggio,
Aye.
Commissioner Martz,
Aye.
Commissioner Topchian,
Aye.
Vice Chair Bergstein,
Aye.
Chair Charity.
Aye.
Can I just clarify, this would mean that we have now are attempting to add 4 agenda items to our next meeting. I think that's a little
That's a little too much.
over-ambitious of us, that perhaps we should not attempt to handle all 4 items and an appeal at our next meeting.
Can we always just defer it during a meeting, or is that allowed? Just say we'll put it off to later?
Say that again?
Can we have it on the agenda but choose to postpone it? Is that an option? Then we can decide then what to postpone.
Well, that
Maybe we'll be efficient.
I
Super
should have
efficient.
come with the motion, but
At the beginning of the meeting, you may amend your agenda, and you can do just that. You can put an item off to another meeting.
Yep, so the motion has passed already, so it's going to be on the agenda, and then we know all together that we can postpone it or defer it if we're running late.
Okay, and I'm sorry, one final thing. I was reading through the whole ordinance, and we're supposed to do a report every year to the city council, I found out, and I don't know if that's been happening or if staff does that, but I just wanted to raise that, and I guess during staff comments, or you can let me know now if we're already doing that, and if not, at some point, we should probably do it.
Do you want to wait for staff comments for that, Mr. Nunes?
Staff report or the commission report?
The commission is supposed to report to the city council once a year about what we've been up to.
I'll cover it in my comments.
Very good. Okay. I, on Tuesday, attended the Human Services Commission to basically give our input on social services. And the takeaways I got from it are, obviously, we've had a lot more interest in our homeless population in West Hollywood. But first and foremost, commissioners, we are a very important commission to this city. I can say that every representative there from the other commissions and advisory boards, the top issues for women's advisory, gay and lesbian, transgender, senior service, they all, at their top of their list was affordable housing in this city and maintaining affordable housing in West Hollywood. That was their top agenda item that they wanted to bring to the Social Services Commission. Human Services Commission. So I'm gonna just keep speaking with those other representatives because they had a lot of interest actually in SCEP, systematic code enforcement, because they, like us, also see a lot of fear and pride issues and privacy issues with their residents and with their constituents in implementing the changes that they'd like to bring to better our city. So I'm just letting everybody know that because we have a lot of friends out there, and if we have something like systematic code enforcement or we have something that we think could benefit this city, please do share it with your fellow commissions and your fellow advisory board members because you'd be so surprised how many allies we have out there. Troy, for instance, at Public Safety Commission, brought up SCEP to me. And really loves the idea and would love if we all partnered together as all of our bodies and pushed it to City Council. So just, giving you some of the bigger takeaways. Those were some of the biggest takeaways.
Just ask, would there be any risk of a Brown Act violation if we were to discuss with, if I were to call all 7 members of a Public Safety Commission, would that be a Brown Act violation for my having that conversation with all 7, or because it's not as a group body? I don't want to cross any lines.
Well, you really run a risk of generating a serial meeting, but if you do that, it's called a serial meeting, and for instance, not to say that it would happen, but there's a good chance that it might happen. And for instance, if you talk to one, and then you talk to the next one, and you share some of the bits from the first one with the second one, and then you do that with the third, all of a sudden you're starting to impart or share, or you're the conduit going between more than one or more than a quorum of the members, and then you do start to run that risk. If you say you went and I talked to this commissioner, that commissioner, this commissioner, and that commissioner, and they all felt that it should be X, all of a sudden you're in that situation where you're creating a serial meeting or you're causing a Brown Act violation.
Would it be maybe a better way to handle it would be to appear at a commission meeting and speak during public comments, saying I'd like to address this issue with the commissioner board? Would that alleviate that?
But you had a thumb up from the chair there.
Yeah.
Well, and also, too, that's why we want to have this discussion about liaisons to the other commissions and advisory boards, because we have friends out there, and they need to know that they have friends in us, too, because they have things that we certainly agree with. Another advisory board, I forget who it was, but I believe it was either Gay or Lesbian or Women's Advisory Board, talked about those mobile units for homeless residents in our city for laundry services and washing themselves, and we had just talked about that. So we have some common ground where we could really do some good for the city, and I think it's important for us to establish these liaisons to the other advisory boards and commissions. And that's it for me.
Just a little thought. You mentioned the affordable housing, how the commissioner was a...
This was Human Services. I went
Human
to
Services Commission. They're in support of affordable housing, and that's great. But I just wanted to ask commissioners, anytime you are out there with the community or presenting to the different boards and commissions, always my kind of a belief is that affordable housing is one thing, but rent stabilized units, it's another thing. So everybody talks in the city about affordable housing, how important it is, and it is important, but affordable housing is not the same as the rent stabilized units. And it's very important for the community to understand that preservation of the current rent stabilized unit and the rent stabilized stock, it's very important. It's
Yeah, and I was using it a bit colloquially.
Yeah, no, I mean,
I meant to, give the general idea that rising rents in West Hollywood and lack of, quote unquote affordable housing, not the legally defined term that we have, is a big issue for these other groups. But yes, I thank you, Commissioner Topchian.
it was just general comment. I didn't mean to.
I just wanted to announce that today in Sacramento, there was a press conference by Assembly members, several of them talking about different housing bills, and 3 of them in particular that are making up a housing tenant protection package are AB 1482, which is authored by Assemblymember Chu. It would institute a statewide anti-rent gouging law to protect against the most egregious rent increases tenants face. The bill would cap annual rent increases at a level above the Consumer Price Index for all rental properties in California that are not subject to local rent control ordinances. This bill would not supersede local rent control ordinances. There was another bill, Assembly Bill 742. I'm sorry, that's not the one I wanted to mention. AB 36, which is my boss's bill, Assemblymember Bloom, he will make amendments to Costa-Hawkins that would allow cities to apply rent stabilization measures to rental units that are more than 10 years old. The bill also allows cities to stabilize rents in single-family rentals and condominiums with an exemption for small landlords who own 2 or fewer rental units. And then the final bill, the third bill is disappeared. I'll have to get back to you on it. Basically, it's Assemblymember Chu's. Actually, the 2 bills I want to announce. That I think we should, or people should pay attention to and hopefully support.
Bill, is it now being considered, you said?
Yes, it's now being considered. It was just introduced recently, and then they did a press conference today on it.
And you'll give us the update on that, won't you? Thank you.
Try to, yeah.
Commissioners, any further comments? Very good. We'll move on from item 11 to item 12, staff comments.
Well, I've filled my page with notes here, but I will be brief. So I did want to take a moment just so that the commission's clear on the item that we brought November 8th, that we didn't have council direction to come to the Rent Stabilization Commission with the amendment to the RSO. As you know, RSO amendments are council prerogative, they're not commission. But the council in the past has heard from commissioners that the commission would like to see those, or at least commissioners would. And so we just brought that forward. We also brought it to you because you had just gone through a year-long process. It had been very involved, and we felt that it was appropriate to bring some item as closure to that pass-through process with the outcome. So I didn't, we don't want to disrespect the commission in any way and going simply back to the council with that, but ultimately their direction was very specific and finite, and it was for us as staff to follow the existing rules in the RSO. So again, I did provide the mechanism by which commissioners can request that item from their council members, or the commission can request from the council. That's the point of clarity that I wanted to make, that it wasn't that we're going against the council's direction to bring it to the commission, and the council was not, they didn't direct a recommendation from you in return. The second point, annual report. So yes, you'll see in the RSO oftentimes the language is that the commission will do this or the commission will do that, and it's kind of the, if you will, the royal we, meaning that the body of rent stabilization will produce this report. Staff has produced the report yearly. Just due to some staffing challenges this last year, the 2017 report wasn't done, but I'm happy to announce that we have hired a new information coordinator. Her name is Yasmin Spiteri. She comes from the Housing Rights Center, and she has a very strong background in tenant protections. She has a legal background, and she's going to be helping us with those annual reports and our newsletters and our website. I did check while the commission was deliberating, and I embarrassingly have to say, we don't have the AGAs on our website, so I'm going to make that correction very quickly. I think that that's a very meaningful piece of information that we have to have out for the public. So be looking for the annual report very soon for 2018. It will be a 2-year annual report. We do have all the other annual reports online and available for the commission to review. Number 3, I'm glad that someone did mention how many items you're stacking on the 28th. Again, I'm not going to be here, so have fun. But in all seriousness, you did just place 4 discussion items plus the appeal. Perhaps some of those items will go quickly. Remember, at the beginning of the meeting, you can continue an item to another date, uncertain or certain. You can also, in the meeting, if it's getting too long, you can also continue those items that you don't get to another meeting, okay? Number 4, I always use, in terms of when we're talking about affordable housing, I'm very clear about housing affordability, or I'll say affordability in the local housing market, because there are some very different challenges, and I think we, by nomenclature, use affordable housing to refer to housing that's built with different subsidies and loans, and there's different requirements, and a lot of people in general are talking about that affordability, that they can go out into the market and just get a place at a realistic price. There's also some thought about using achievable housing as a different word. It hasn't caught on as much, and so I really refer to it as housing affordability. You'll may be interested to know that at the next council meeting, April 1st, we're bringing a recommendation to explore 4 pilot programs to just do that, to generate greater affordability in the local housing market. About a year ago, we did bring a study, 90-page study to the council. We spent some good time exploring a number of different options. We came up with 9 potential programs to explore, to generate or to grow that affordability. So we've whittled it down to 4 that we think are going to be something of interest. One is a small sites acquisition program, one is a home ownership program, and the other 2 I'll leave you in suspense over, partially because it's just late and I've forgotten them. My 5th item, last one. Just wanted to mention as well bills that I found interesting, and Commissioner Bergstein, you might want to share this with your neighbor as well. I believe it's Nazarian that's sponsoring a bill. I don't know the number. What caught my mind was that it would be a 30% tax credit to the owner for seismic retrofitting costs. Nazarian. Those are my comments.
Do you questioned on home ownership, that would mean not only a home, but condominiums. Would that be correct?
Yeah. The intent here, we do have an affordability program, an inclusionary housing program, and we have so far produced rental units. And our goal is to create opportunities for people to be homeowners as well as continue to be renters. I, as the housing manager, see a real deficit here in West Hollywood that I say that we are 80% renter, and when you look around at the greater region, it is far higher in ownership. And I think that it's wonderful that we're able to allow and provide these great rental opportunities. But ultimately, when you leave your rental unit, you leave your rental unit with the clothes that you own and the furniture that you own. You don't leave with equity that you gain in owning a unit. And I want to create that opportunity for those households and those members of West Hollywood that have the ability or the want or the drive or the earnest to be a homeowner. I want to try to create programs or an opportunity or a path in, a door into homeownership. So we'll see.
And that 40% tax credit is for the property owners, or that's for owners and the tenants? For both?
So I read the summary of the bill, and it's owners. I'm assuming it's not going to the tenants, it's just going to the owner of the building.
And I wonder why, because the fees are split 50-50.
It's for anyone who's doing the seismic retrofitting, and it may be just right across the board, commercial, everyone in general would receive a 30% tax credit. I think that's pretty stellar to offset costs for seismic retrofitting.
Any further questions or comment for staff? Okay, at this time we'll adjourn the meeting. The next regular meeting of the West Hollywood Rent Stabilization Commission will be on March 28th at 7 p.m. in the West Hollywood Public Meeting Room, Council Chambers. This meeting is adjourned.